Testing 1 2, testing 1 2. Testing 1 2, testing 1 2. All right, welcome back, people. It's your boy Supreme Decisions, and today we're going to talk about a controversial, shouldn't be, issue that a lot of people run into when they're dealing with issues in state court that they want to remove to federal court. Now, I'm going to talk about this from one aspect because the great thing about it is, even with me, I hear a lot of people say you can't remove a state criminal case to federal court, while I do it constantly. And it's one of those where a lot of people have a misnomer of what can and can't be removed, how to remove it properly, and then once it's removed, how to make sure it's not remanded. Now, I'm not going to go into great detail, but I'm going to give you the information that you need so you know that is not only possible, but why I'm able to do it over and over and keep it removed and win with it. So, I want you to imagine sitting in a state courtroom facing criminal charges. The jury pool is local, the judge is local, and the prosecutor knows the courtroom inside and out. Suddenly, your attorney announces, "We're removing this case to federal court." Or maybe you're on the prosecution side and you learn the defense is attempting this very move. What does that mean? Why should anyone want to take a criminal case out of state court and into federal court? And what can be done to stop it? Because here's my great portion in doing this. Because it's not just a technical maneuver. Most people will attempt to remove their case, not knowing why they're removing, not using the proper removal, and then not working it or wording it properly. Now, let's say they get it to the point to where a judge is actually looking at it. The first thing that's done, they don't know how to answer anything that comes against it. This is one of the reasons why this is going on today. Because when we're doing this, it's done as a power play. Federal courts come with different rules, broader protections, and sometimes more sympathetic forum. Why? Because it's for the protection of the people and the restrictions of government officials. But the law is strict. Not every case can be removed. And today we're going to unpack how removals work, the statutes that govern it, the strategies used to achieve it, and the tactic the state can employ to slam the door shut. Because we don't need to know just one side. We must know what we are going to face in, not in every situation, but possibly in your next situation. And along the way, we're going to lean on Supreme Court decisions that set the boundaries of this battleground. By the end, you'll understand not only the legal mechanics, but also the chess game that removal represents in the larger fight for injustice. Now, yes, I'm still a little stopped up from earlier because, again, I went outside, did a little filming, running around, doing things, enjoying myself and enjoying the cooler weather. So it's still hot, it's still the desert, but because I saw something today that was kind of amazing, so I wanted to just get a little bit of that warmth on me. And then I came back inside, and it's still, I got a cold in here. So anyway, the legal framework for removal. Now, here's the great part about it, right? Because I used one with a young man who had removed a couple of cases prior to. He ended up having those cases dismissed, which kind of made me think, why would he come to me? And the biggest thing was, he said, I knew I did those wrong. And I thought that was amazing because generally the biggest issue that someone has is to win and think they can duplicate it or it's the right way. He understood he won twice, but it was wrong. So whenever I sent it to him, he had 1,001 questions. Now, understand that he also compensated me for my time in answering those 1,001 questions. Now, what we're going to do is look at a couple of them, and then we're going to look at the why. 28 USC 1442 deals with federal officer removals. I want you to listen to that because it allows federal officers and those acting under them to remove cases to federal court if prosecuted for actions taken under the color of office. These are the things where they are being charged in a state court that should be governed by the rules of the federal court. Now, I've actually seen someone use this. They used it wrong. The case was remanded. Didn't know how to get it back up. However, the correct 28 USC 1443 Civil Rights Removal Statute. Why? Because most people have no idea what civil rights means. They just think it was some things that Martin Luther was marching for. And that's not how that works. So the context of it is to allow the removal of criminal cases where the defendant is denied or cannot enforce in state court a right under federal civil rights laws, which include due process of law, which is governed to the states and applicable to the states under the 14th Amendment. This is what the removal is done, and this is what the removal is for. Because understanding the context, why you use these things, is paramount about you winning. Because again, wording, the verbiage, and putting everything in perspective properly helps you win. Now, one of your cases that's going to guide it, if you're going on one side, is going to be Mesa Beach, California. And the removal under 1442 requires a colorable federal defense. If you're not a federal agent, don't worry about that one. However, Georgia v. Rochelle. Georgia v. Rochelle is one of those that I've used several times because here's the great part about it. It understands how to make sure the federal court has jurisdiction over your case and make sure you're protected in the same instance. Because the removal is proper where the defendant is being prosecuted for doing something a federal civil rights law expressly protects. I'm going to say that one. The removal is proper where the defendant is being prosecuted for doing something a federal civil rights law especially protects. Now, this is the great part about it because this is the reinforcement when you're talking about, in most cases, First Amendment auditors. And I love to talk to these guys because a lot of them are like, I know. And then when you show it to them, they're like, oh, I didn't know this. And here's the great point. Why would they? That's not the part of this that they do. So when they're having these conversations with me, these are the things that I talk about because the education about it is understanding the application of it. And that's the one thing I tell everybody that separates me from everyone. I do this at a high level. So I understand not only what's going out, but what's coming back. And understand we're going to keep doing that because that's all I do. I'm the new DJ Khaled. All I do is win. Now, you just have to be ready to get on the train to do so. Now, the city of Greenwood v. Peacock. The removal under 1443 is narrow. It does not apply to every civil rights claim, only where the denial of rights is explicit and unavoidable in state court. Again, this is where the verbiage come in, the language of the court. This is why whenever you're writing it, too many details can blow up your case and have it remanded without even having it really challenged. So understand, City of Greenwood VP Cop, the removal under 1443 is narrow. It's not something broad, and specificity is required. And going through that, I'm going to give you grounds. Grounds for the removal as a federal officer in their defense. Police officers, federal contractors, or military personnel claim they acted under federal authority. Now, again, this is something where they have people in place for them. Most of them not working on their behalf, but they have people in place for them, which is why the removal is labeled specifically for them. An example, an ICE agent charged under a state law for conduct during the immigration raid. This is possible. Not likely, but it's possible. Because we do watch them being, hell, they've deported, at least 4 Americans that we know of? At least 4 in the last, 2 months. So just imagine the conduct that's being, the actions that are being inflicted upon them, even when they're not doing something wrong. But again, they're acting under the jurisdiction of a federal order for the most part, because they're following orders based on what they're given, which is allowing them to violate rights. So that's why if they're charged in a state, they have an opportunity to have it removed and heard fairly. Now, in a civil rights denial for your defense, where the state prosecutor itself targets constitutionally protected conduct. Now, like I said, the easy is a First Amendment auditor, because most cops don't know regular law, let alone understand constitutional law. Most of them don't even read their actual oath of office. Now, the example I use, civil rights workers in the 1960s persecuted for peaceful demonstration. The removal was granted because state law directly conflicts with federal rights. Because remember, I've gone over this. Federal rights outweigh state statutes. Federal statutes outweigh state statutes. These are the things where I talk about the state statutes, codes, and ordinance change from state to state. Law does not, because all states must coincide with federal statutes. And if they don't, you now have a challenge. Hence what we talked about earlier. The resisting with no resistance. That's a violation that's amazing. It's an amazing, easy violation. And a way to get out. Now, the colorable federal defense requirement. Now, again, like we spoke about the ICE agent, they must show a legitimate federal defense, not just a vague reference to constitutional rights. So again, even they have to show, it'll most likely be written orders or having someone that's higher ranking than them come and testify that they were giving a directive. So they must follow it because they have no choice. Just watch A Few Good Men. They actually explain that. Now, here's where it gets fun. Because when you do the removal, it must be filed in a certain manner. And certain verbiage needs to be on there. Because even when we're going through and we're putting it together, certain aspects and certain procedures must be labeled properly. And generally, giving too many details puts you under fire. And that's what happens with most people, because they want to put in every statute that they know. They want to put in every Supreme Court case that has nothing to do with what they got going on. And they believe what they're doing is adequate. But the whole point is leveraging policy and understanding proper procedure. And when you're filing based upon the Federal Rules of Civil Procedure, 28 U.S.C. 1455, gives you the specificity that governs criminal prosecutions. because they even tell you the time in which you have to do it. And most people think, oh, well, they said it was only this many days. And here, I'm going to give you the greatest hint. If you haven't gone to trial yet, you still have an opportunity to remove it. Because again, line upon line, precept upon precept, there's a procedure for everything. And the more time that's left in there, that gives you more of a ground to use. Because even in the context of I actually removed one that violated speedy trial request because the prosecution didn't have anything. I even spoke about the dude that was being charged with in 2 separate cases for the same gun that wasn't his in a company truck based off an illegal search. Like, all of this was compounded, so whenever it happened, these things were then thrown out. Why? Because they were able to move forward understanding the proper verbiage and the proper, basically, time and in the context of what was needed for that case. So, and that's it was real direct to the point. We didn't do a whole lot. I think both of those removals were 1.5 pages. Like, their signature went in the middle of the second page because I did not put in a whole lot of extra details that no one cares about. Keep it as short as possible, and you keep it moving. Now, here's a cute couple things I'm going to give you that the state uses to block removals because, again, they know they have the greatest opportunity, even though it's 26%. Their greatest opportunity is in state court. Nobody wants to go to federal court. That's the easy. No one wants to challenge you in federal court because they don't follow federal law. So removing your case to federal court properly offers you the greatest opportunity of having your case dismissed. Because again, they're not taught, they're not smart, they're not taught how to solve a crime. They don't speak the truth because they can't use regular language. They're using stock language. And then no one that puts these together are doing it based on law. They're doing it based on intimidation and revenue generation. So that's why we come up with that and we challenge it, because even the removal is a challenge to the process. Now, what the state generally counters with, the first thing that you'll see is a motion to remand back to the state court under 1455B4. The biggest thing about that will be the next piece of paper that goes along with that motion to remand is the 12B6. A lot of people think they understand how to answer it. Most people do it. I want to say that one's also at about a 70% clip. They don't answer it properly. So I want you to understand the numbers. 5% of people challenge it, right? So then out of that challenge, let's say 70% of those people actually go to federal court. Out of that 70, only 30%. Now keep in mind, it ain't 30% total. It's 30% of 70. So if we're using 100, 70 people actually use the notice of removal. 30 of those people are actually doing it right. So that leaves a total of 40 people out of that 70, or hell, it might be 21% or 21 out of the 70 that's doing it correctly. And the reason being is because of most people don't know the language of the court, or they'll put in too much detail, or they'll try to answer something that's not the time to answer it. And all of those are issues because the process remains the process whether you know it or not. Now, when you're trying to do it at a different level, you must understand it at that same level. Now, even an argument relying on Mesa v. California to say the defendant isn't truly acting under federal authority. And this is one of those that will be used against a federal agent. Because even with the limit to 1443 to clear civil rights violation, they'll cite PCOP to narrow its scope. Generally, claims of unfairness in state court aren't enough because you have to understand what applies. The reason it's narrow is because they don't want you to remove it. Always understand that. The reason why specificity is king is because it does not allow them to worm out of anything later. And then the next part is procedural deadlines, missing deadlines, improper filing, failing to identify specific federal statutes, specificity in the writings, incorrect writings, vagueness. And a lot of times, again, those are things that are curable if done correctly and proper, which is why if you don't know, use someone that does. Because again, you're only going to pay with time or you're going to pay with money, but you're going to pay with something. And the biggest part about this is to never stop learning. Now, here's the bottom line. Removing a criminal case from state court to federal court isn't some routine motion. It's a high-level maneuver that can reshape the entire battlefield. The defendant gains access to a new jury pool, new rules, and sometimes a new, more neutral forum. But the statutes are tight and the Supreme Court has drawn narrow boundaries. Unless you are a federal officer or your case is in a direct attack on federally protected civil rights, removal is an uphill climb. And even if you get in the door, the state will be right there with a motion to remand, using every procedural substantive argument that's available to push the case back. So for those that are attempting to do this, and they are attempting to do it by themselves, make sure you contact me first. Because the key takeaway is this: you got to understand the statutes. You got to marshal your federal defenses aggressively and anticipate the counterpunches. For yourself, know that this tool exists, but not a magical bullet, because it's not automatic if it's not done correctly. And even though the prosecutors, you must understand that their attempt at removal or your attempt at removal is going to be under attack, and they're going to attack it at its very foundation, making sure it's written properly, making sure you know how to defend it. And whether there's a federal strike or an actual procedural error, it's going to be under attack, and your responsibility to make sure it's answered properly and timely. And at the end of the day, removal is a courtroom chess match between the state and the defendant. And it goes to the power of either the state's going to have it or it's going to go to federal supremacy. And it requires not just knowledge, but the execution of perfect strategy. That's what I got for you for right now. Again, Supreme Decisions. I'll see you guys later.